Perfect. So let's get started. How is everyone? I hope everyone is doing good this evening. So I hope you guys are in the right place. We are going to be talking about trust tonight. So is anybody in the room familiar with trust entities, with being a trustee, anything like that? You can come off of
Little,
mute. Huh?
a little.
A little? All right, perfect, perfect. So we're gonna dive into it now. So you should get some foundational information so that you can make an informed decision to see if a trust entity is a good entity for you to operate and build trust. So I am going to mute so that we can get started. Let's mute. Perfect. All right, so the right way to build wealth. So become a wealthy trustee. So my name is Christina Yvette, and I am the creator of the Wealthy Trustee Program. So we're going to go through that right now. So disclaimer, this is not legal advice or tax advice. So I am not a licensed attorney or a certified public accountant, okay? My name is Christina Yvette. I am a passive income strategist. So I have actually been a trustee since 2015 when I bought my first real estate property. And that property, I was actually flipping it. So it was it's a high liability company. I have a real estate investment company and anything can happen. So I didn't want to put myself in a position where I could be sued and they could take the asset. So my mentor advised me on land trust and how to, operate a trust, create a trust, and, become a trustee and actually operate the trust. So that is what I've been doing since 2015, and I have helped hundreds of people create passive income through, using different financial tools. And let's see. So I wanted to show you guys my structure just so that you guys can have an example, okay? So the name of my real estate company is called Elite Homes Enterprise LLC. And you can see that I'm the registered agent of the company. And the authorized member or the owner of the company is actually Urban Holdings Inc. Okay, so that's the S corporation that I utilize as a holding company in order to hold all of my businesses. Okay, so now if we go to Urban Holdings, so this is the Secretary of State's website for the state of Florida. Okay, so I showed you guys the LLC. The LLC is owned by a holding company. So now we're going to go research the holding company. So it's called Urban Holdings Inc. And we're going to click on that, take a look at this legal entity that's active. And you can see that I'm the registered agent for that. And the CEO of the company is Ways to Wealth. So what is that? That doesn't sound like a human, right? So it's actually an entity. It is a trust. The name of the trust is called Ways to Wealth, and the owner of the holding company is the trust. So I just wanted to show you guys, the structure that I'm going to be educating you guys on in a little bit, okay? All right, can you still see my screen?
Mhm.
Perfect.
Yes.
All right. So the objective of tonight is for you guys to know what a trust is, for you guys to know what the contributors of or who the contributors are, for you guys to know how to set up a trust and operate it, for you guys to know tax strategies, wealth strategies, and asset protection. So you need to be able to protect your assets, okay? So how do these companies pay no taxes, right? So you have big billion-dollar companies like Amazon, Berkshire Hathaway, and the Trump Organization. So a lot of these companies, they have publicly came out and said that they don't pay any taxes or that they pay less taxes than their secretary. So they do that by utilizing these type of financial tools, right? They utilize trust in order to be able to reduce their tax liabilities, okay? So one example I want to show you is the Trump Organization, right? So the Trump Organization, you can see here that it's established in New York and that the ownership is private. So you can't physically see who the owner of the Trump Organization is, but it shows you that the company serves as a principal holding company for Trump's business ventures and investments, okay? So it is a holding company, but they don't show you who the owners of, even though these are, you know, public figures and we know that they are the owners of their company. On paper, you can't prove it, okay? So that is a position that you want to put yourself in. You want to put yourself in a position to where all of your assets are private, even your businesses, right? Your businesses, your homes, your cars, any type of investment accounts that you have, anything that you consider an asset, you want to be able to have it, you know, public, have it private so that no one knows who the owner is, okay? So let's dive in. So this is a $1 bill. And my question to you is, do you see the word trust? So please come off of mute and answer the question for anybody and everybody who can do that.
Yes.
No.
Yes.
Okay.
Oh yeah,
awesome.
in God we trust, yes.
Okay, awesome. Okay, so what a lot of people don't know is that you are only allowed to utilize the word trust, like in writing, if you are actually talking about a trust entity, right? So a lot of us think that the word "in God we trust" means that we trust God, but in all actuality, that is the living, breathing trust of the United States. So the name of that trust is called "In God We," right? So I have a link here to show you guys that this is actually registered in the state of Pennsylvania. So it is "In God We Trust / the United States of America Incorporation." So a lot of people also do not know that the United States of America is a business, right? So it's incorporated just like all these other big businesses. So just keep that in mind, that if the United States of America is utilizing a trust, maybe you should also utilize a trust, right? There's a lot of benefits to utilizing a trust, which we're going to dive into in a little bit. But in actuality, a lot of people don't know that the United States actually creates a trust for you. So if you are born here in the US, then they actually create a Sister-Q trust when you are born. And the way that they're able to do that is utilizing your birth certificate, right? So that is actually a contract. That's a contract. Your footprint goes on it, and that is your parents allowing them to create a trust, right? And you have to keep in mind, like, when we get all these benefits from the state, right, or from the government, how are these benefits being paid out, right? So Social Security, right? That is actually backed by the trust that they created when you were born or when you became a citizen. So just keep that in mind. Okay, so what is a trust entity? Very simple. A trust entity is a contract, and it's a contract between many different parties. These are some of the parties involved. So you have the grantor. The grantor, another name for the grantor is the settlor, and that is the creator of the trust. So the individual that creates the trust for the benefit of somebody else, not for the benefit of themselves, okay? So typically that individual is called the beneficiary or the inheritor, okay? And the beneficiary is the person who's actually going to receive the assets owned by the trust. Whenever the trust is dissolved or expired, then those assets will be transferred to the beneficiary. Or you can decide to continue the trust for generations and generations to come. So we're talking about generational wealth here and how to effectively create generational wealth, right? So the grantor, they create the trust, and usually they are the ones who fund the trust too. So they will create a bank account, they'll put, whatever starting capital they want, or they will transfer personal assets into the trust. Then you have the trustee. So the grantor appoints the trustee, which is typically called the first trustee. And that trustee is the controller of the trust. So that individual actually has all the power and control when it comes to the trust. So they're the individuals that are going to be operating the trust on the day-to-day basis. And what they're doing is they're the ones buying and selling, real estate or any type of assets. They're the ones that are managing all of the funds. If there's any type of like litigation or anything like that, they are the ones that are facilitating. So they are the fiduciary for the trust, and they are doing it for the beneficial interests of the beneficiary, right? So that is some of the parties that are involved. There are other parties that are involved, which we'll go over in just a minute. So what is a trust indenture, right? So a trust indenture is the actual contract, right? That's the contents within the trust, right? So you have your declaration, which you are either, operating a business for business purposes, or if you're operating like a land trust for real estate purposes, if you're operating like a private family trust just to hold assets. So that is actually the agreement and, all of the restrictions and stipulations and powers that you put in place within the trust. So you can put pretty much anything that you want in the trust. For example, if you wanted, the beneficiaries to have a 4-year college degree, or they would not be able to benefit from the trust, you can put those restrictions in there, okay? So I will definitely show you guys the trust in just a moment. So now let's talk about appointed duties, right? So we spoke about the grantor and that individual being the creator of the trust, right? So it's up to the grantor to actually appoint the trustee and choose someone that can be trusted, right? That actually is going to accept all of the duties that comes with that appointment of them being a trustee, because they are the ones who are going to be really investing the funds. They're going to be the one managing everything. So it's up to the grantor to choose someone who is qualified and can actually serve within that capacity of being a trustee. Another thing that the grantor does is they transfer assets into the trust, right? And they can, it could be any type of assets. So it could be intellectual property, it could be royalties, it could be stocks, bonds, cars, properties, land, anything like that. So whatever you consider an asset, it can be that, okay? So now the thing about a grantor is that they do not have any power whatsoever. So you do not want to be in that position. You don't want to be in the position to where you create a trust, but then you're powerless, right? So like I said, the grantor actually creates the trust for the beneficiaries. Usually the beneficiaries are, people that, loved ones. And so with that being said, they then give the power to the trustee and they pretty much walk away from the trust. So they only serve those two purposes: to create the trust and to appoint the trustee. And then everything else, like all of the management, goes to the trustee. So all of the role, the responsibilities, the duties, everything. Okay. So when it comes to you setting up a trust, you can be the grantor and trustee, but that is actually creating a living trust. And a living trust won't hold up in court because usually judges, they look at it as if that is you, right? They look at it as an extension of you and that you just created it for your benefit versus for the benefit of someone else. So you don't want to do that. You don't want to be in the position to where the judge can pierce your trust because they don't think that it's a viable trust, right? So keep that in mind because typically what I tell people to do is to choose someone that they trust to be the grantor. It could be like a grandparent, a parent, a sibling, anyone, for them to actually serve as the creator on paper. Okay. So that's like the best thing to do in this situation. So now the trustee, what are their duties, right? So their duty is to appoint a successor because in the event that you as the trustee become incapacitated or expire unexpectedly, you want to know and be certain that the trust is going to, continue in its operation, right? Especially if you have a bunch of assets owned by the trust. So you need to be able to appoint someone to be the successor. Sometimes trustees, they will appoint like an adult child or a sibling or someone that they trust. In the event that they don't have anyone to be the successor, then they can actually get a general trust manager or a third-party company. There's a lot of third-party companies, even financial institutions, that will serve as the trustee for your trust, but it comes with a cost. Okay, so that's going to be at the expense of the trust estate. So the trustees also, they manage the trust assets, right? One thing with the trustee, one of the benefits is that if the trust owns any type of real estate, the trustee can, stay in that real estate for free and at no cost. And the trust estate will be responsible for all of the, financial obligations that come with that house, right? So utilities, mortgage, maintenance, anything that comes with that house. Okay. So just think about it for the benefit of yourself that if you have a house that's in your personal name, now what you can do is you can deed it over to the trust, and then now the trust will be able to cover all the expenses related to that particular home. Trustee is also responsible for investing trust funds. So like I said, the trustee is the fiduciary. And so you don't want the trust funds to stay stagnant, right? You want to be able to have that money flowing and in circulation and generating more money, right? Because if not, then you're going to put the trust estate in a detrimental position because if the money is not growing, then that means that the trust funds are being mismanaged and it's not going to last for however many generations your goal is. So the money or the trust funds need to be able to be invested in generating more money. Okay. Beneficiaries. So the beneficiaries, their main duty is to gain a clear understanding of the trust, right? So they need to be able to go through the trust contents, read all of the bylaws, and understand fully what the do's and don'ts are within the trust. They also need to be able to understand the mission statement of the trust, right? Why was the trust created? What's the mission? Which is pretty much to maintain a quality of life for the beneficiaries, right? They also need to be able to understand the trustee duties because at the end of the day, the beneficiaries are pretty much the owners of the trust, right? They're the ones who at the end, when the trust is dissolved, they're the ones who own all those assets. So they're not the ones controlling the assets. So they need to know what the duties are of the individual that are controlling the assets. Okay. And then another appointed duty is a protector. So a protector is actually an individual that you trust, and that individual can be appointed by the creator, or they can also be appointed by a trustee. and it's for the beneficial interests of the beneficiary. So basically, the protector is going to watch over the trustee. So watch over, their day-to-day operations, watch and do an audit on the financials to make sure that they are investing properly. And they are doing that just to protect the beneficiaries, to make sure that the trustee is actually dealing with the trust legally and lawfully and not going to pretty much steal trust funds and stuff like that. Okay. So the protector usually is optional, and some people decide to do it, some people don't. So typically, if you yourself are the trustee, then you're not going to really appoint someone to watch over you, because you created the trust and you know that you are, acting legally and lawfully. So in that instance, what they'll do is they can actually appoint a protector to be in the future, once they're no longer serving as a trustee. So there's different types of trust. You have an express trust, which is pretty much a written trust. You have implied trust, which are oral trusts, which you can't really trust in oral trust, right? It's like me and you saying, exchanging 2 and 3 words, and that's a trust. So you have land trust. Land trust is specifically for what it sounds like. It's specifically for land and real estate and, property. You have living trusts, which you use while you are living, right? So that is when you're putting yourself in the position to where you are the creator and you are the trustee and operating the trust. And that one is similar to a will. You have revocable trust. Revocable trusts are trusts that actually can be changed and amended by the creator. So generally, the creator, once they create the trust, if it's a revocable trust, they can make any changes. If they decide that they want to put a house into the trust, and in the future they want to take it back, they can do that. You have charitable trusts, which are pretty much for whatever charities that you guys want to contribute to. You have testamentary trusts, which are pretty much just like a will. And wills are, let's just talk about wills. Wills are not the best way in order for you to leave a legacy for your family, right? A will actually not prevent you from going to probate. We're going to talk about probate in just a minute, but probate is when your family has to go through the court system to be able to transfer those assets that you left in the will. So if your grandmother left you a house, that house is still under your grandmother's name. So the only way that you are able to transfer that house from your grandmother's name to your name is by going through the courts and by having that decision made by a judge. Okay. And so you can actually avoid all of that. And you definitely want to do that, because going through probate is actually putting or doing a disservice for your family, because they're going to sometimes, it's a lot of legal battles, and there's also a lot of fees involved, because you have court fees, you have lawyer fees, because you can't, you're not going to represent yourself in court, so you're going to have to get a lawyer. So with that being said, you are all of these fees, like the court fees and the lawyer fees, all of those are actually coming out of the trust estate. So if you decided that you wanted to leave your family $1 million, by the time probate process is done, they're probably going to be left with $600,000 after all of the court fees, and after it, sometimes it can drag on for years. Like I have a client of mine that she's been in probate for 2 years now. 2 years, and she's anticipating another 6 months. And she cannot get her father's house. Her father passed away, and she is unable, she's fighting with a sibling, a half sibling, and she's unable to get her father's house. So you do not want to put your family in that position. And that's why when it's so important when you guys are building this wealth that you think about how is the wealth going to be transferred? Because when we expire, right? We're dead and gone and we're in heaven already, but we leave, chaos behind because our family now have to fight each other, or they have to go through, jump through hoops just to be able to get the assets that you left, just to be able to get the money that you left. So think about the process of, I'm building this wealth. How am I going to transfer it to my children? How am I going to transfer it to my loved ones, right? Keep that in mind. So the best type of trust that to actually create or implement is an irrevocable trust. And the reason why is because it's going to hold up in court. So let's just say in the event that you are actually going through like litigation and stuff, an irrevocable trust, it can't be changed or amended by the grantor. A lot of people think, oh, I'm not going to set up an irrevocable trust because then I won't be able to change anything. But if you do not put yourself in the grantor position, which is the worst position to be in when you're setting up this trust, then you will be able to, because the irrevocable trust can be amended by the trustees and beneficiaries, or if you set up a board of trustees. So it cannot be amended by the grantor. So pretty much it means that if I'm the creator and I create a trust for, my children, I can't take back the property, or I can't change anything within the trust, or I can't dissolve the trust as the creator. But you are going to be the trustee. So you have the powers to do all of those things. Okay. So pick the right position. So back to irrevocable trust. The reason why it's the best type of trust to set up is because it's going to hold up in court, right? The reason why you're setting up the trust is to protect your assets. So in the event that you are going to be sued, you're going to litigation, you're going to court, this type of trust, depending on how you set it up, if you set it up through, non-statutory common law, then it doesn't fall within the jurisdiction of your state. So it has to go all the way to the Supreme Court in order for it to be carried out in court. And with that being said, there's something called contract law, right? Everything that we do is contract. A lot of us, we don't realize that. But for example, the lights are on in my house right now. How are they on? Because I have a contract. I have a contract with the utility company. I have a contract with the electric company, with the gas company, with the water company. These are all contracts that I have in order for me to be able to, sustain my living in this home. So a lot of the things that we do are contracts. If you're going to college, that's a contract. If you have an employer, that's a contract. So there's something called contract law and trust law, which their irrevocable trust falls within that. So if you go to litigation and your trust doesn't fall within the jurisdiction of the state and it has to go through the Supreme Court, and the judge sees that it's an irrevocable trust, 9 times out of 10, they do not want to pierce the corporate veil. They do not want to pierce that trust because then that is violating contract law. Okay. So that's why it's you putting yourself in a better position by operating with a trust, because a lot of companies, once they see that they're dealing with the trust, they don't even want to waste their time going through litigation because it's a trust. All right, so there's one particular trust that I want to talk about, but like I said, there's a lot of trust out here. The one trust that I do want to talk about is called a 508c1a trust. I'm not sure if any of you guys have heard about this type of trust, but it has the name can be, interchangeable. So you have ministry trust, which is a 508c1a. You have church trust, you have convention, you have faith-based organization, right? And pretty much what it is it is a tax exempt trust. Okay. So under the IRC code, you have a 501c3, which is a nonprofit tax exempt entity. And you have a 508c1a, which falls within the tax exempt bracket. And that is pretty much a trust that is not a foundation that can actually be tax exempt, right? So this is what the true separation of church and state is. It is the ability for you to not have to pay taxes, right? Not have to report anything to the IRS, not have to report any of your books or do any filings. Okay, so there has to be like, some type of, like I said, some type of entity or structure to where you are able to reduce your tax liabilities, or you are able to separate that, that religion from the state. And so this is actually one of them, which could work to your benefit, because you're able to, if you want to use this type of trust, you're able to build wealth faster by reducing your tax liability. So what is a FBO? Let me just quickly show you guys. So this is the Internal Revenue Code. I know it's like super micro and you probably can't see it, but let's go down to exemptions. Okay, so let's see, exceptions, actually mandatory exceptions. So we are gonna go down to B. So any organization which is not a private foundation, sorry, and the total gross receipts which are in each taxable year are normally not more than $5,000. Okay, so that is the definition of a 508c1a. So it's under the 508 code for the IRS. Hold on one second. So anyways, with that being said, it says that you can't have any gross receipts within that $5,000. So when you're operating this type of business, like I said, it's a nonprofit, it's a tax exempt business, and any type of income or anything that's coming in is actually going to be considered as a donation. Okay. Asset protection. So let's talk about asset protection, because this is the #1 benefit for actually creating a trust and operating your life with a trust. Okay, so you want to be able to put yourself in a position where you are operating 100% privately. Okay, and let me tell you the benefits of doing that. For example, let's say that you own a house, right? I know a lot of us on this call, we are homeowners, which is actually one of the most proudest things, right? First time home buyers. And we are so proud to, to be the Lord of our land and to actually own property here in the United States. The thing about that, or the disadvantage, is that you have that property, but that property is under your personal name. So that property is tied to your Social Security. That property, if it's searched, so what you can do is you can actually go, it's considered public record. So you can go on your county website and you can actually search for the owner of the house, right? So if they were to put, they meaning, let's just say a lawyer, right? A lawyer or somebody. if they wanted to look at who owns this particular property, all they have to do was put in your address and the owner's name is going to come up. So your first and last name is going to appear. They also have other search options to where you can actually put in your first and last name. So let's just say that I wanted to be nosy and I wanted to know how many houses Cynthia owns in our actual county. All I'm going to do is I already know Cynthia's first and last name, like she told me. So all I have to do is just go onto the county's website, put Cynthia's first and last name, and the search results are going to show me that she has 10 properties in that county. So that is how easy it is for someone to know what your assets are, for someone to know what your net worth is, because you are operating publicly. So that puts you at a disadvantage because Cynthia, for example, she has 10 properties, and these 10 properties are actually rentals. So let's just say that, she had some issues with a tenant and the tenant wants to sue her. And so now they actually are, they're able to go after her, right? So they start a lawsuit and they go after her. And at that point, if she loses this lawsuit, let's just say that her tenant had a slip and fall. Accidents happen all day, every day. And if the lawyer, does their due diligence, they're able to find out that Cynthia has these 10 properties. They can seize all her assets if she loses that lawsuit. And then that's it. In a blink of an eye, Cynthia goes from owning 10 properties to 0. And she goes from, having a net worth of 2 million to 0 and bankrupt, because of one accident, because she decided that she wanted to be a proud owner and have her name all over the public records and have everyone knowing that she owns 10 properties. So that is actually putting you and your family at a disadvantage. You do not want to be in that position to where you are that low-hanging fruit, to where you are, liable and able to, get sued, and people are able to easily take your assets, right? So when it comes to privacy, you definitely want to have as much privacy as humanly possible. So if you are driving a car, that car is actually going to be in the name of your trust. And if that car gets into an accident, you have limited liability. So if you own a home, but that car is under the trust, they can only sue that trust for whatever that trust has. And typically with vehicles like that, you only want to have those high liability assets with one trust. So one trust, one asset. That's the best way to do that, okay? So you want to be able to protect yourself. You want to be able to protect your growing wealth. You want to be able to protect your family's legacy. So let's talk about asset protection, right? So you can protect yourself from bankruptcies, right? And the way that you bankruptcies, divorces, lawsuits, heavy taxation, probate, and foreclosure. So let's talk about divorce real quick. You're married and you love your spouse, but then 10 years down the line, you decide that you don't love your spouse anymore, right? And in the meantime, you were actually acquiring assets throughout your marriage. And these were, your personal investments. So with that being said, if these assets that you acquire, if they're under a trust, then when the divorce attorney for your spouse tries to look up your assets and they see that you only have the marital home, then that is the only thing that's going to be included in the divorce. If you don't disclose that you have 20 properties scattered across the city, they're not able to find it. Why? Because like I said, if they go through the public records, they can't prove that that property is yours, because if they look up the property and the property is owned by 123 Main Street Trust, how are they able to gain the contents of that trust to know who the trustee is or who the beneficiary is? They're not able to do that. They won't even know where to begin to do that. So you are protected when it comes to divorce because your spouse is not going to take half of your, half of the wealth that you accumulated while you guys were together because you were thinking smart and decided to put that property under a trust. Okay. Same thing with lawsuits, right? I want to give you guys an example of the Kennedys. So the Kennedys, John F. Kennedy and his family, they are multimillionaires, maybe billionaires, who knows, right? They're wealthy. They're a wealthy family. Well, they were actually sued, right? They were sued by a young lady and she actually won the lawsuit. And so they were sued personally. So the Kennedys were sued personally and the lady won the lawsuit. But because the Kennedys operate with a trust, they have all of their assets under trust, and the lawyers were not able to prove anything, they actually didn't have to pay anything out because they claimed that they were broke. They claimed that they had no money, that their income was absolutely zero. So the individual who actually won the lawsuit didn't get any money. So that's the position that you want to put yourself in, because you have to understand that, like, the United States, we all know, is a sue-friendly country, okay? So people are always looking for somebody to sue. And if you could be their next victim, then that's going to happen. So you need to think about, like I said, you need to think about your legacy. You need to think about your loved ones, right? Heavy taxation. So there's an example that I love to give, but there's a lot of taxes that you can save by utilizing a trust. One of them is inheritance tax. Why? Because your loved ones are not inheriting anything. The day that you expire, and let's just say you got 10 houses, you have a bank account under the trust name, you have your stocks and bonds under the trust, your cryptocurrency, your life insurance, everything, your car, everything is under the trust. The day that you expire, there is no transfer of ownership. Why? Because everything remains under the trust. Right? So you don't have to change it from your personal name to your children's name, which is good. So technically there's no inheritance. They didn't inherit anything because they are already the owners of the trust. So there's nothing that needs to be done, which is the best stress-free transfer that I would even know of, right? Because at that time, when you lose a loved one, the last thing that you're thinking about is fighting over a house or who's going to get what. Trust me. So if that's one step, less of a stressor for them, then that's a good thing. So heavy taxation. So you don't have to pay a death tax, because I'm not sure if you guys know this, but the government taxes you when you die. Okay. So keep that in mind. A death tax and inheritance tax. Also, you have like sales tax, property tax, right? So for example, if you are operating with a 508c1a tax exempt entity, then you are eligible for property tax exemption. And the way that works is, and with this type of entity, it can only be one property. So you can't have 10 or 15 properties and be exempt from all 10 properties. You can only choose one property. And with that property, all you have to do is go down to the tax assessor's office or the county recording office and apply for property tax exemption. And all you have to do is give them the declaration of your trust, let them know, hey, this is a tax exempt entity and I want to be exempt from property taxes. I have a client that her property taxes are $8,000. And so right now she is in the process of finalizing her trust. And that's the first thing that she's going to do. So she is going to put herself in a position to where she's going to be saving $8,000 annually, and she can do anything and everything that she wants with that $8,000. She can invest it into, into real estate. She can save it. She can, create, a custodial account for her kids. She can do anything with that. So just think about the amount of savings you're going to have, and think about how you can accelerate your wealth building, building strategy by saving on heavy taxation, right? So let me give you another example. Steph Curry, right? My son, he plays basketball. He loves Steph Curry. And I was looking at a documentary, and in this documentary, it was talking about how Steph Curry had a contract for $250 million. And with this contract, he actually had to pay the IRS $144 million in taxes, because he lives in the state of California. So they're going to take half of what you have. So just imagine if Steph Curry was operating with a trust and he was able to save some of that $144 million, because I think he has 2 or 3 children, right? So he has a legacy that he's building. He has wealth that he's creating, but he put himself in a position to where he's not utilizing the right tools that the ultra wealthy use in order to, save on taxation so that they can accelerate, their investing, right? So that is super important, and I definitely want you to keep that in mind. And I had touched on probate already. So like I said, if you decide that you want to utilize a will in order to be able to, distinguish how you want to leave your assets to your loved ones, that will is going to go into probate. And the probate process can be very brutal, very brutal. It can take years, especially if you have family that's not agreeing on how they want to take ownership of these assets and these properties, right? So you want to avoid probate at all cost. There was something on social media with what's this guy's name? Chad something. He's the guy who did Black Panther, right? And so, he was young, in his 40s, died, left, I think it was $2 million. And guess how much went to probate court? Out of the $2 million that he left his family, right? I think he had a wife or a girlfriend and some parents, no children, $2 million. $900,000 of that $2 million went to probate, went to lawyer fees and court cost. So think about that. Do you really want that to be you? To where you bust your butt, you accumulated this wealth, a couple $1 million, and half of it is going to go to court fees? I don't think so. I think that we want to preserve as much wealth, and we're building this wealth for our family and for our generations, right? Our kids' kids. And so you just have to keep that in mind. So that is another thing, dealing with asset protection. So let's move on. Oh, I got lost here. Geez. There we go. How to transfer wealth, right? So like I said, a lot of people, they just leave a will and think that that is the best thing that, or the only thing that they know, because some people fail to do their due diligence, they fail to do research, and they fail to know that there are other options when it comes to transferring your wealth, right? So stewardship is very important. And it's better than ownership, right? Ownership is, like I said, when you feel like, yeah, I'm the owner of this property and I'm proud and I'm going to let everyone know that I'm the owner, that, I did this, right? Right. Even that's how we are with our businesses too, right? We want everyone to know, I'm the CEO, I'm the owner of this business, right? But that puts you in a detrimental position when somebody wants to go after your business. So you want to put yourself in the position to where you own nothing but control everything. And I'm going to repeat that because it's such a profound, way of looking at it. Own nothing but control everything. That is the name of the game, right? A lot of us, we play Monopoly. And when it comes to Monopoly, we're, learning the road of building wealth, right? But how are we going to protect that wealth? How are we going to transfer that wealth? Those are questions we do not even ask ourselves. So you want to put yourself in the position to where you are a good steward of your wealth, to where you are controlling your wealth, but you are not owning it on paper. On paper, the owner is an entity. Who is the owner of the entity? We don't know. We have no idea. How can we find out? We don't know. Where's the trust documents? We don't know. Okay. So that is the position that you want to put yourself in, to where you are a good steward. You are controlling your wealth and you are building it for the benefit of the people that you're going to leave the wealth behind to, and their children and their children, their children. So typically, when it comes to building generational wealth, usually the wealth is already disappeared by the third generation. But if you put these type of tools in place, to where in a trust, you are able to put restrictions, rules, regulations for how the wealth is managed, and that trust is actually going to be a living, breathing entity for 100 years, then you are able to make sure that that wealth is preserved, right? So you have stewardship, you have UBI. What is UBI? That's units of beneficial interest. So that means that it is, another term for it is trust certificate units. It's just like a stock certificate. So you know how companies have stock certificates when you go ahead and you purchase them on the stock market? Well, a trust also has certificates as well to show ownership of the trust, right? So generally, the way we set it up is we will set up your trust to have 100 trust certificate units, which is equivalent to 100% ownership in the trust. And you distribute it however you want. So for example, let's just say that you have 4 children and you want to distribute it equally. So that means that each child is going to have 25% ownership, or 25 trust certificate units. So you're actually going to distribute 25 certificate units to each child, okay? So now let's just say, for example, that it's time for distribution, right? Let's just say that you own 100 houses and these 100 houses made $100,000 for the month or for the quarter. The way that you're going to distribute that is by how many trust certificate units those beneficiaries own. So if they own 25 trust certificate units, then, and the income is $100,000, then that means that they're going to get a distribution of $25,000. I hope that math makes sense. Okay. So with that being said, let's just say that there is a beneficiary that now doesn't want to be a part of the trust anymore. So you have 4 kids, now you're going down to 3. Well, in the event that that occurs, what happens is that that one beneficiary, they get a distribution, they get their assets transferred to them. So if, like I said, if you own 100 houses, then those 25 houses are deeded over to that beneficiary. That beneficiary now turns in those 25 certificate units and they are removed from the trust. And now those units are redistributed to the remaining beneficiaries. Okay, so that's pretty much how you show ownership of the trust. Preservation. Preservation is super important because if your money is not growing, it's dying. If your dollar is not going out and bringing back 25 cents or another dollar, then you are at a disadvantage because it's depleting, right? It's depleting in value. We have inflation. Inflation is, at its all-time high. So when it comes to preservation, what is the best way in order for you to preserve wealth? Well, one way that we talk about is utilizing insurance, right? Insurance is very important. We use insurance for our houses, our cars, and for our human self. So when it comes to a trust, you actually have human, what is the name? Human assets. There we go. Human assets, right? So you have physical financial assets, which is the money that you have in the bank, but then you have human assets, which are the beneficiaries, which are the actual people involved with the day-to-day operations. So if you have a beneficiary that's a human asset and that asset dies, what happens? You need to be paid out. You need to be compensated because you just lost an asset. Okay, so what you do is you actually put life insurance on every single beneficiary, and the owner of the life insurance policy is the trust. The beneficiary of the life insurance policy is the trust. Okay, and you are actually, insuring the beneficiary. Okay, so that is the best way to secure the preservation of the wealth, because if you lose a beneficiary, you're going to get paid out a death benefit. That death benefit, $2, $3, $4, $5 million, that goes straight into the trust. And then what happens with that $5 million that just got paid out because that beneficiary expired? Well, that money is then rolled over into the market or rolled over into another policy, rolled over into real estate, rolled over into an investment to where it's going to be doubled, tripled, and quadrupled. That is how you're able to preserve your wealth, by utilizing insurance, right? This is what a lot of the wealthy people do. And this is actually what I do, right? I have an IUL policy on me and all of my children. So we are actually creating a trust, right? So what is the process of creating a trust? Well, like I said, it's a contract, it's an agreement. So you can actually use a template and you can figure out whatever you want to name the trust, right? So you can name the trust anything that you want. You can call it, Mickey Mouse Trust if that's what you wanted. You can call it your first and last name if that's what you wanted. You do not have to use the name trust in your trust entity. For example, at the beginning of this call, I showed you what the name of my trust is, right? Ways to Wealth. The name trust is nowhere in that name, right? Another strategy that you can do is if you,
I told you I'm doing something.
oh, I'm sorry. Hold on one second. I have to mute somebody.
Right there in the moment.
I apologize, guys. Let's see here. Okay, great. So another strategy that you can use is you can actually put LLC if you want it, right? You can put LLC at the name, at the end of your trust, right? So if I wanted it to be, Main Street LLC, I can name my trust Main Street LLC. And then when I'm out operating, it actually looks like an LLC, even though it's not an LLC, right? You can put company at the name, right? So this is a business trust and you are operating it like a company, but you don't have to let everyone know that the actual entity or structure is a trust. So like I said, it's an agreement, it's a contract, right? So you're going to have a contract. So typically, the trust templates that I use, they're like anywhere between 20 to 40 pages, right? Just depending on your operation and how you're going to use it and what type of bylaws you want, right? So once you are done structuring your trust and creating it, you are going to get it notarized. Once your trust is notarized, then it becomes legal. Then it's a living, breathing entity. And when I tell you living, breathing, I literally mean it, because your trust can actually do anything and everything that a natural person can do, except for give birth, right? So like I could give birth, but my trust can't. But I could write a book and my trust could write a book. I could create a course, my trust could create a course. I can build credit, my trust could build credit. I can buy a house, my trust can buy a house. I could buy a car, my trust could buy a car. So you understand the concept, right? Your trust is a living, breathing entity, and it can do pretty much 99% of the things that you can do as a natural person in this state. So you want to also keep that in mind, because you don't have to, operate utilizing your social security. You are out here putting your social security number everywhere. Like everywhere that they hand you a document, you just putting the numbers. But where is your privacy? Now they know what school you go to, they know where you work, they know who you're voting for, they know everything. So you want to be able to have some type of privacy to where, people can't just look up your address or search your name, look up your address, and then show up at your house, right? That is something easy to do. And so you don't want to put yourself in that position, right? So you want to be private. So like I said, once you are done with setting up the trust, and once you get it notarized, it's legalized. After you get it legalized, then you're able to apply for your EIN. So you're going to be filling out the SS4 form, which is provided by the IRS. You can just go on irs.gov and you're able to download the form. The form takes a while, so I would recommend that you actually apply online, because the application process takes less than 10 minutes in order for you to be able to instantly get your EIN, right? And so when you are actually applying for an EIN, they're going to ask you, what type of legal structure are you applying for an EIN for? And you're going to put trust. Then they're going to ask you what type of trust, and they're going to list like 15 different types of trust, and you're going to press irrevocable trust, okay? Then they're going to ask you, who are you? So they're going to ask you for your name, your social security number, your address, and you as an individual are only able to apply for one EIN per day. So if you have multiple trusts that you're setting up, you can only do one trust per day. Okay, but once you're done and you verify all the information, you are able to instantly download your EIN number. And the reason for your EIN number is for banking purposes. That's the reason that we're going to put. Okay, so now once you're done, hold on, let's see what's going on here. Once you're able to get your EIN number, then you are able to qualify for a bank account. So the way you set up your bank account when it comes to your trust is, you as the trustee, you are authorized to do everything on behalf of the trust. You are the operator of the trust. So the first thing that you have to do is you have to do your meeting minutes, okay? So you need to have a meeting with yourself, your board, your co-trustee, whoever, and you need to determine, what bank are we going to use in order to set up our bank account? Are we going to use Wells Fargo? Are we going to use Chase? Are we going to use First Citizens? Who are we going to use, right? And then once you decide which bank you're going to use, you're going to document it in your meeting, and you're going to add that to your trust, okay? So at that point in time, within that meeting, you are just letting it be known and documenting that, one, you are eligible to get login information, you're eligible to get the debit cards, the online information, you're able to open up the bank account, all of those things, right? If it's going to be a checking account or a savings account, you are the signatory when it comes to you opening up these bank accounts, okay? So at that point in time, in regards to the bank, you definitely, the best practice is for you not to open up a trust bank account with a bank that you already bank with personally, because that's going to put you in a position to where you can easily commingle funds, and you don't want to do that. You want to operate legally and lawfully, and you do not want to mix personal with trust funds. Okay, so the best practice is to have separate bank accounts at separate banks. So if I'm personally dealing with Wells Fargo, then I'm going to set up my trust account with Chase Bank. Okay, so that's the process of opening up a bank account. Now, the process of transferring real property is pretty simple. So if you no longer want to be the owner on paper when it comes to your house, then what you're going to do is you're going to do a quit claim deed. Okay, it's super simple. And with that quit claim deed, you are going to deed over the property from your name or from Mr. and Mrs. Smith to the family trust. Okay, and then at that point, you sign, you get it notarized, and you record it with the county recorder's office. Okay, so that is extremely, that's an extremely simple process. Generational wealth. So this is exactly what we are talking about. We are talking about building generational wealth. So right now, what I'm going to do is I'm going to give you some wealth building strategies and tips that you can use in order to, implement so that you can start building wealth. Okay. So the wealth building formula. The number one thing is structure, right? You have to make sure that you are structured properly. Structure is everything. Structure can make you or break you. Okay, so like I said, you want to be a steward, you don't want to be an owner. So you can utilize entities like holding companies. At the beginning of this call, I showed you guys that I utilize a holding company, but I didn't tell you really the reason why. And so the reason why I utilize the holding company is because when I first got into real estate, I was flipping houses. Flipping houses is dangerous, guys, because you're using contractors and subcontractors, and you're breaking down walls and building up walls. Anything can happen. Somebody could get electrocuted. Somebody could step on a nail. Somebody could get hit by something. And at that point in time, that's a recipe for disaster. You're putting yourself in a position to where they're going to take the house from you overnight. So that's why you want to, one, utilize a trust, or two, utilize a holding company, right? So that's why I utilize a holding company, because I don't want to be putting myself in that position, because I have an LLC. But what does LLC stand for? A lot of us, we think that, okay, the LLC is the end all be all, but in actuality, it's not. It clearly says limited liability for a reason. That means limited. It does not say full liability. So when it comes to you having an LLC, right? Let's just say something happens in your business. So I'm going to use myself as an example. I'm not sure what kind of businesses you guys have, but you can drop it in the chat and let me know. So I have a real estate investment company. And with this company, like I told you, it's an LLC. And that's what I use in order to, do the day-to-day operations, right? So with this company, let's just say that I was doing investments, and there was a slip and fall or anything like that, right? At that point in time, I could be sued. And when the LLC goes to court, right? When the LLC goes through litigation and they pierce the corporate veil for that company, and they decide, hey, you owe $1 million. They're going to come after my house. They're going to come after my bank account. They're going to seize every single asset that is under Christina Yvette, right? And then at that point, I'm broke. So you don't want to be in that position by solely operating with an LLC, or by operating with an LLC, but clearly on the Secretary of State's website, it shows that you are the owner. Okay, so that's why you want to utilize a holding company, because now the holding company is the owner of the LLC, which puts that first layer of protection. So you are protected initially by the holding company, okay? The holding company can now own all of your LLCs, all of your companies, your S corps, whatever it is that you have, okay? The holding company can own all of those entities. Now, the holding company is going to also be owned. Who is the holding company going to be owned by? They're going to be owned by a business trust, right? A business trust, and you can choose what type of trust it is. So typically I recommend that it is an unincorporated business trust, okay? With that being said, you definitely want to be able to conceal your identity. And so this is actually the second layer of protection when it comes to you operating your business, right? So first, the LLC is owned by the holding company. The holding company is then owned by the unincorporated business trust, okay? So I really don't know at this point how they're going to find out who you are, okay? Because there's two entities that are already in front of you. Now, the actual beneficiary of the business trust is going to be your private family trust, right? And so your private family trust, now you are able to, now you're able to do all your day-to-day stuff. So let's just talk about like taxes, for example, right? So it depends on like what state that you are in and stuff like that, if you have to pay state taxes or federal or all this stuff. But a business trust, an unincorporated business trust is taxed at 37%, right? And so with these entities, these are pass-through entities. So whatever money, let's just say that your LLC made $100,000, that money is going to be distributed to the owner. The owner of the LLC is the holding company. So now the $100,000 is going to go to the holding company. The holding company now made $100,000, right? The holding company is now going to distribute all that money to its owner, which is the business trust. So now the business trust has the $100,000. So now at this point, they owe $37,000, right? 37%. So the business trust, what they are now able to do is they are able to distribute 100% of their money to their owner. So their owner is going to be your private family trust. So your private family trust is now going to have the $100,000. So at this point, all of the other entities, the LLC, the holding company, the business trust, their tax liability is zero now because they did 100% distribution, right? So now when it comes to the private family trust, this is where you're able to do your day-to-day living, right? This is where the mortgage comes out, the grocery comes out. This is where the insurance comes out, private school, whatever it is that you have on a day-to-day basis that benefits your family and that you are able to expend in order to sustain your life, right? So now let's just say that you expend all the way down to, from that $100,000, you have expenses, that expense goes all the way down to whatever, $10,000. Now at that point, that $10,000, you can pay taxes on it, or you can donate it. And you can donate it to who? You can donate it to your tax exempt trust, right? Your nonprofit trust, because you have a mission. You are a philanthropist. You actually, are out here feeding children and, helping other people with whatever it is that they need, right? You're providing scholarships and grants and all kind of stuff, right? So you have a mission. And whatever it is, your mission, your purpose, your goals, whatever it is, you want to utilize that tax exempt trust in order to be able to provide those charities. And so what you can do is you can donate that to your tax exempt trust, and your tax exempt trust is tax exempt. So there's no reporting, there's no filing. So at that point, there is no tax liability. And then you have a circle of trust, which is where you have multiple trusts, right? Like I said, if you have 10 properties and you want all 10 properties to be tax exempt, then you have to have 10 trusts, but you'll have one main asset holding trust that's going to be the beneficiary or own those 10 trusts. So that's what I'm talking about when it comes to a circle of trust, right? You have entities that own other entities, okay? Sometimes it can get complicated, but it just depends on you as an individual and if this is actually worth it for you to be structured the right way to actually build wealth the right way, transfer wealth the right way. Let's talk about credit. So when it comes to credit, like I said, these are living, breathing entities. They are businesses. They are able to do anything that you're able to do. So if you are able to pull credit and buy a house, the trust is able to do the same thing. So the trust is able to actually build business credit, right? You can get them set up with Dun & Bradstreet and Experian and Equifax, and you can actually start creating a paydex score and actually start building credit, right? Getting lines of credit, getting loans, getting getting anything that you need when it comes to corporate credit. So that's one thing. So that is a benefit to you that you are now able to utilize this this entity in order to build credit, because credit is, credit is king or queen, or I don't know what they say nowadays in the industry, but credit is important. I think we know that. So another thing is that because you have a tax exempt entity within your structure, you can apply for grants and you can apply for nonprofit grants, right? And so grants are free money, right? Because you applied for it, because you took the time, because you outsourced and you had a grant writer, doing your applications for you. Whatever the process is, you're able to now facilitate and get grants. So that is a huge benefit for you, because if you're utilizing credit, if you're building credit and utilizing lines of credit effectively and leveraging them, and you have these grants and nonprofit grants that you now qualify for, then at that point, you can go to the next stage, which is invest, right? Because let's just say you got $100,000 line of credit. What are you going to do with it? You're going to invest the funds, right? So what are some investments that will be lucrative for you when it comes to stewardship, when it comes to you actually building this generational wealth for 5 to 6 generations down the line? Well, you can open up a brokerage account. Me, I am biased. So I love Fidelity. That's who I mess with. But you can get your brokerage account with anybody, right? You got M1 Financial, you got Charles Schwab, you got all these, big names, right? So choose a brokerage account, whichever one that you want. And at that point, you can set up different types of accounts. One account that I recommend, and these are for my parents here, right, that have like children that are under 18 years old. You can actually get a custodial account or a UTMA account for your children. Me, myself, I have 3 children, 11, 4, and 3 years old. So I'm building wealth for them, their children, and their children, okay? So this is why I do what I do. So now you can actually get a custodial account for the children, right? And the custodial account is going to be owned by the trust, but it's going to be for the benefit of your child. And you can actually invest in stocks, bonds, or whatever you want with that account, right? So if you wanted an account for your child, you can get a custodial account, because a lot of us parents, we are so focused on ourselves. We are so focused on, yeah, I have a brokerage account for me, but you're trying to build generational wealth. Why not have a brokerage account for your 3-year-old child, right? For them to have their own account. And then if they wanted to, once they reach age, whichever age you choose, if you wanted them to get access when they're 21, 25, 18, whatever it is, then at that point you can let them do that. So why not have a custodial account, a UTMA account for your child and build their wealth, for them, versus you only focusing on your brokerage account and building wealth and, hey, they'll benefit when I die. No. So you need to simultaneously build your wealth and their wealth as well. Okay. So UTMA custodial account is 1, and 2, just a regular brokerage account, right? A regular brokerage account where you invest, right? So one of the investments that I teach about and that I love is, and that's actually passive, is index funds, right? Index funds, they are so fun because you just set it and forget it, right? It's not like you have to be a day trader and start trading, these different stocks like Apple and all this stuff, right? So you can choose whatever index you want. There's plenty of them. You have the Dow Jones or you have the S&P 500, right? And I'm biased, like I told y'all. So I'm all for the S&P 500. Why? Because it gives you diversity automatically. The S&P 500 stands for Standard & Poor's. It's an index that actually tracks the top 500 companies in this country. So I absolutely love that because you are already automatically diversified. Instead of you just putting all of your money into Apple or all of your money into Facebook, and then let's just say Facebook disappears off the face of the earth tomorrow, then there goes your net worth, right? You thought, okay, you was putting all of this faith into $1 billion organization, and then they fell off the face of the earth, right? The internet went down and that's it. Or you can be diversified and you can actually invest in the top 500 companies. And the thing that I love about this, like I said, is passive, right? So there's nothing that you have to do. With an index fund, it's not like a mutual fund where you have a manager, right? You are just, like I said, setting it and forgetting it. So you're putting it with the S&P 500. And let's just say that there is a company that goes bankrupt within that 500. They're removed from the index. And then whatever company was sitting at 501 now moves up into the index. So you are really at a low risk when it comes to this type of investment. And then another thing that I like is, one, I'm all about diversify. So you do not only want to invest in the United States. I understand that majority of us, we live here. And some of the top countries or companies in this country, right? But what you also want to do when it comes to diversification is you also want to invest in other companies, right? Other countries. So like you have Asia, right? You have big companies like Mercedes is in Germany. You have other companies like Samsung, right? Is one of the most popular phones, and they're like in Japan. They're like in a third world country. So you can actually invest in other indexes that are international, okay? So that's what it is with brokerage accounts. Now let's talk about index universal life insurance policies. You could also do this with a whole life policy, but when it comes to your insurance policy, a lot of us, we think that insurance is for when we die, but it's actually, the best use is actually to use it when we are living, right? And so the way that you can do this is depending on who your agent is and how you get it set up and structured. What you can do is, like I mentioned earlier with preservation, you can have your trust own the insurance policy, right? So they're going to be the owner and the beneficiary of your insurance policy. And then what you can do is you can overfund your policy. So how does that work? I'm not sure if you guys heard of infinite banking, but when it comes to your insurance, you actually have a cash value, right? And with that cash value, you can actually borrow from it. And it won't be at the expense of yourself because this is an asset. So let's just say, for example, that you make $10,000 a month, right? What you want to do is you want to pay yourself first. And this is what I mean by pay yourself first. You want to, that whole $10,000, let's just say that it came in February 1st, $10,000, right? A lump sum. You are going to pay your policy. You're going to make a deposit into your policy. And now your cash value is going to go up by $10,000. But you have to pay your bills, right? You have to pay grocery, you have to pay gas and, your utilities. So what is going to happen is you're going to call your insurance company and you are going to take a loan. You are going to borrow out that money from the actual insurance company. So your policy is going to stay put. That $10,000 is still sitting in your cash value. and it's actually being invested, right? So with a whole life policy, typically you'll get like an annual return of 4%, but with an index universal life insurance policy is tied to an index. And usually the market gives you about 10%. So you call up the insurance company, you let them know, I need to borrow, you know, I have $10,000 cash value or whatever you have in there, you need to borrow it out. So the insurance company, they're going to look at your cash value, and they are actually going to lend you the money from them, right? It comes from the insurance company. It doesn't come out of your policy. And now let's just say that, so it's a loan and they're going to charge you interest. Let's just say they charge you something small like 2 or 3%, right? But you're making 10% a year and they're charging you 2 to 3. You never have to pay back that loan. So that loan is actually taken out of the death benefit. So you can start doing this every single month, where you're putting in 10 and you're taking it back out, but that 10 is staying in as cash value and it's actually working for you and it's accruing 10% annually. And now that 10,000 that you took out, you can do whatever you want with it. You can pay your overhead or you can invest it. You can invest into real estate, you can invest it into crypto, you can invest it into whatever you want. So you have to, so keep that in mind. If you don't know, if you don't know about insurance, get informed. Same thing about real estate. I gave a couple of examples, and same thing about, cryptocurrency, right? So let's move on so that I can take some questions. Okay, bankrupt the trust. So this is it's kind of controversial and I'm not going to really touch on it too much, but I just wanted to let you guys know, because I'm super transparent. When you see famous people, and let's just use Donald Trump, for example, or 50 Cent, or some of these athletes. When you see them going through bankruptcy, sometimes the bankruptcy is intentional. Sometimes they use these trust assets, right? They use the trust entity in order to build assets, and then they transfer the assets to another trust, and then they bankrupt this trust, right? Bankruptcy is I'm sorry, I could hear a couple of people, but bankruptcy is totally legal, but like I said, it's controversial, so I'll leave that right there. Okay, so take action. Right? Take action is just very important. Don't just take the information that I have provided you guys tonight and, let it go in one ear and ride out the other and not do anything with it, right? This trust can be your new form of doing business. It could be your new form of making money and creating generational wealth for your family. It can actually solve a lot of your problems, right? It's an exceptional asset for protection, for tax savings, and if it's only going to happen if you properly operate this type of entity. So you have to think about your business trust as a Google, as a Facebook, as as one of the major companies in the world. That's how you need to operate your company, because that's how these companies are operating. The Amazons of the world, they're operating like this. And so that's how you need to leverage this type of entity and use it that way, right? So if you want to work together, we can definitely work together. I have 2 options that I offer people who are interested in getting structured property, and they are interested in learning more about setting up a trust and protecting their assets. So I have a do-it-yourself course where there is a bunch of videos. Right now, there's 35 videos in there, video modules. You have lifetime access to it, and it's just a bunch of resources in there. So you have all the templates, you have all the instructions on how to set it up, how to get your EIN, how to get your bank account, how to, fill out your templates for your meeting minutes, all of these things, right? And that is, you can get that course for $9.97. And then I have a done with you service. So if you are, thinking that you're not able to do it yourself and you want some one-on-one help, then I can definitely help you set up your trust. You are actually going to get lifetime access to the course. Your trust is going to get set up the right way. And it's going to be a series of like 5 to 6 Zoom calls, just depending on you. unlimited Q&A, and that option is $14.97. So it's up to you. But the website is www.wealthytrustee.com. So I will definitely put that in the chat for you guys. And the last thing I wanted to do was show you guys the trust. Hold on one second. All right, let's see here. Okay, so this is the course. I just wanted to show you guys the course and show you guys the templates that we use. So this is the course. It's a video course, like I said, and you'll start all the way at the top at the introduction, and then you find out what a trust entity is. So what is a trust? You find out the different appointments that you can do, the different duties, the benefits of the trust. You'll set up your 508c1a trust, and you'll go through, that entire process, your private family trust, tax strategies, asset protection, how you, set up all of these different, things and transfer your assets. And then we talk about wealth creation when it comes to investing, and then you have your resource section. Okay, so now I want to show you guys a trust. So this is one of, sorry, I was all the way at the bottom. So this is one of the trusts that we use. This is one of the trust entities. So everything that's in red, like I said, it's pretty, excuse me, I've been talking too long. It is pretty self-explanatory. So anything that's in red, you'll go ahead and fill it out. So you're going to put the name of your trust. You're going to, let's scroll down. You'll put like your state, the date that it was established, whoever your grantors are, whoever the trustees are for the trust. So pretty much everything you fill out, right? You got the names of the trust and stuff like that. And then we'll scroll all the way down to the bottom. So this is all content that I teach you. This is, the Constitution and the bylaws when it comes to your trust entities. This is just one of them, okay? And then once you are done, then you are going to get it notarized, okay? So you're going to have it signed and notarized, and that's when it becomes absolutely legal. So do I have any questions? I know I've been going on for a while. We started at 8 and it's 9:30. So I know that you guys have some questions. Go ahead and let's see. All right, Mr. Bay, I see that you have your hand up. Can you unmute and ask your question, please?
Yes, hi.
Hi, how are you?
Well, thank you for having me.
All right.
I-
Thank you for being here tonight.
My pleasure. I've been studying trust and things like that for a while, but I've been all over the place gathering information from everywhere and following a few trustee gurus. It seemed like you were the best person to bring it all together for me. So,
Thank you. Can I just say thank you?
yeah, certainly.
Thank you for that compliment. I can definitely receive compliments, and I do appreciate that so much. Thank you.
It's a pleasure. But I have a question about the grantor.
Okay.
Is this a grantor or a non-grantor trust? Would this be considered non-grantor?
No, it's a grantor trust. So you actually do need a grantor.
Right. Okay. When I mean non-grantor, is like the arm's length distance thing. Like when you mentioned that the grantor has nothing to do with it because it's an irrevocable trust. That's what I mean by non-grantor. Is that the case?
Can you say that again?
Like when the after the trust is set up, because it's irrevocable, the grantor no longer has anything to do with it.
Correct. Yes, that's true. I thought you meant that you don't need to actually have a grantor on paper.
Right. No, just from my studies, it would seem like the difference between, just correct me if I'm wrong, the difference between the grantor trust and a non-grantor trust, the non-grantor trust will be irrevocable because the grantor can't do anything or make any changes after the trust is done, right?
Yes, yes, that is correct. And the grantor trust is the living trust where you are the grantor.
Right, right. So, which means in a non-grantor trust, anybody, I could pick a stranger off the street to be the grantor,
Yes,
right?
that's true.
Okay.
Yes.
Okay, that's where my confusion came in, right? Because, okay, another question is, who can be the grantor? Can it be a family member, or should it be a non-interested party? But can it be a cousin or something?
Yeah, it could be anybody. You can pick family or you can pick non-family.
Okay, and the only reason why I'm asking you all these questions about the grantor and the non-grantor position, because I believe I saw a video earlier in the week that you made. I'm not sure if it was Instagram or something, and you mentioned the bank account, the online bank account, and the requirement of having the social security number of the grantor. That kind of threw me for a loop, because would it be in a non-grantor's trust if I use a non-interested party? I don't know if they would have, I would think they would have an issue with providing me their social security number to open that account.
That's true. Yeah. So it just depends on the bank. Every single financial institution is different. So some will ask for the grantor information and some will not, because with some trusts, the grantor might not even be living anymore. So they're not required to ask you for the grantor information. So it just depends on the financial institution.
Okay, got it. And my last thing, I'm sorry to hold you.
No problem
Apologize.
at all.
On the course, right? For some reason, I don't know, the last two modules of the course, the last one, it says it was supposed to be updated January 13th. I have no videos there. And the one before that, I only got the last three. Like you were just showing the modules on the screen.
Yes.
And yeah, my last module, I don't have, it says it's supposed to be updated January 13th, but it still hasn't been updated. And
Okay.
the one before that, it's only 3 videos showing you. I think you showed like 5 or 6 in that.
So
module.
it might be your particular account. I'm gonna have to double check because I had like 2 people reach out that they had like login information or a problem. So I will definitely check your account to find out, why it's not showing on your end.
Okay, thank you so much. I
You're
yield.
so
Appreciate you.
welcome. Thank you. Thank you for asking those good questions.
My pleasure. Thank you.
Anybody else have any questions?
Yeah, I got a question. Are you there?
I'm here. How are you?
Hey, pretty good, pretty good. This is Alva Collins. You did a very good job. A lot of intense information.
Thank you,
Uh,
Al.
you
We
did
spoke
good.
on the phone, didn't we?
Yes, we did. Yes,
Okay,
we
awesome,
did.
awesome. Now I recognize the voice.
Okay, good deal. I was wondering, because I didn't catch that you actually put the trust together for your clients, right?
Yes.
Is that correct? How much in general? I know it's probably a broad price point and timeline, but could you give me an idea of what that cost structure is for you? They retain you to do this?
Yes. So if you want to work with me one-on-one is $1,497. And then we will set up all three entities. So the unincorporated business trust, the private family trust, and the tax exempt trust.
Okay. And how long does that take?
So it depends on the person, because you actually have, you have to you have to know like who the parties are involved. So you have to be able to provide a grantor, to be able to find out if you are the trustee or if you have a co-trustee and stuff like that. So it depends on you, but typically we'll get it done in like 4 to 5 Zoom calls.
Okay. Also, because I understand that different states in the US as well as overseas have different laws pertaining to asset protection and trust, like Wyoming, for instance. Do you jump into situations like that where, like the Caymans and so forth?
No. So I know like there's a lot of individuals out here that they do foreign trust, but I do not, I do not assist with foreign trust.
Okay. Okay. Good deal. Okay. Okay. And I guess my last question, One of my clients wanted to set their trust up. They own some property in the state of New Jersey. And somebody else on the line is my partner, James Graham. We were trying to set this client up with a trust in New Jersey, and it was becoming very difficult because of the laws within that state. And if I remember right, their land was in, they wanted to put the land in a trust for protection when they was getting ready to do their development. But you would look into all of that kind of stuff for $1,400 and see how we could do a workaround. Am I correct?
Yeah, absolutely. That's true. And, it just depends on how you set up your trust too, because if you go like with the lawyer, then the lawyer is within the jurisdiction of that state. But if you actually set it up as like a non-statutory trust, then they can't provide those restrictions or limitations when it comes to like New Jersey.
Okay. And my last and final question, how can we contact you directly? Do you have like an email, phone number you can give everybody?
Oh, yes, I
Because
do.
all my clients aren't on here. A few of them are.
Oh,
but not all of them.
okay. Yeah, you know what? You just reminded me. I was supposed to put it in the chat. My apologies. But yes, so I'm gonna put it in the chat. The number is 305-749-9215.
Slow down.
I know.
Say it
I'm
again.
so sorry. I'm so sorry.
Okay, what is it?
305-749-9215. So that's
Oh,
the
say it slower than that. I mean, I can't even
oh,
say it real slow, like
okay.
305. Go
Oh, I
ahead.
love it. 749-9215.
Okay,
So I
9215.
yeah,
And that's 305 Erico, right?
yes.
Oh, gotcha. Okay, cool.
Yep, and then I just put the website. So if anybody is interested, in signing up for the course, they can go to www.wealthytrustee.com.
Mhm.
And then
Okay.
I'll put in the email address too.
That'll be good.
So I hope you guys can see the chat.
Mhm.
Okay.
Good deal.
I have a question.
Hi, how are you?
Hi, my name is Berthina, and I just wanted to know, because you mentioned about if you were married and you marital property, but if you're married and you acquire property during your marriage, you can't put that in a trust and it be considered untouchable by your spouse.
So so when I mean that goes to operating privately. So for example, if you're married, legally you are supposed to, everything that you acquire while you're married is joint. But if you are doing stuff separately and your spouse doesn't know, because sometimes not all of us get married for the right intentions, right? So if you are doing stuff separately and your spouse does not know and you put it under a trust and no one finds out, then it's undiscoverable. That's what I mean. So I'm not talking about in a perfect world. I'm talking about if you are, in a situation where you want to protect yourself and separate stuff, even though you're married.
Okay. Thank you.
You're so welcome. Thank you for being here. I actually wanted to, I don't know if there's any other questions, but I wanted to invite my friend and associate. His name is Antoine Persons. He is also a trustee. I want to see if he's able to talk and just let you guys know a little bit more so that you can hear it from someone else, how it is to operate a trust and be a trustee. Antoine, are you available?
I am. So how is everyone doing? So Christina, first I wanted to say you did an awesome job tonight. So I've been operating as a trustee, I would say since 2012. I originally started out purchasing properties using land trust, and which kind of led to me, starting like a family foundation and also a family trust. So it's been working out really well for me. One of the things I was going to ask you, Christina, I know the last gentleman asked you, did you actually set up trust for people? But I think you actually walked them through the process, correct? And they set it up themselves?
Yeah, we do it together. So we do it
Right.
together on Zoom. So it's both of us, hand in hand. I'm holding your hand through the whole process.
And then I think the last lady, she asked about being divorced. And I think the answer to that really is if you're purchasing property within a trust, that's not any personal asset anyway. So the personal individual does not own those assets. The trust actually owns those assets. So if a divorce did happen, that individual doesn't personally own it. So the spouse wouldn't be able to come after it anyway because it's business assets. The only ones that can disperse assets from a trust is the trustee. And it's, the trustee, if the trustee is getting a divorce, the trustee doesn't own the property because it's the trust as well. So the only way that assets will be able to be dispersed from the trust if the trustees decide that they want to make a disbursement.
Perfect. Thank you so much, Antoine. So thank you so much for sharing that and just encouraging, people that they definitely want to be in a position to where they are, stewards of their wealth. They're creating wealth the right way. They're transferring wealth the right way, and they are protecting themselves and their families, and they're growing wealth. Do I have any other final questions? I see that it's 9:48 and I've kept you guys over time, and I do apologize for that.
Christina,
Yes, ma'am.
my name is Telma Key, and in your price of the $14.95, does that include access to all of the videos?
Yes, ma'am, it does. You have lifetime access to all of the resources and the entire program. Plus, you have access to me.
Okay, thank you.
Thank you for that question.
Hi, I'm Tamara Wells of Wells of Wellness on this call. How are you?
I'm doing good. How are you doing? Nice to meet you.
Thank you. I'm doing much better now that I've actually come in on this call. I don't think that it was a half an hour, it was on time, but after listening to you, I that there was just an eye-opening and a brain dump into my brain of the things that just kind of popped in, how to organize and structure and how important that what that means and how you can actually move funds. So I appreciate and I value all of the content and the intellect that you put into this resource for us first and foremost.
Thank you so much for that. I appreciate that. Thank you.
You're very welcome. But my question was more of a complication because my scenario is not just me and my businesses trying to structure. I'm going to ask from out of the box kind of perspective. Right now, where I'm having concerns is a property that belongs to my mother, and it's not yet established who it should be deeded to. So I'm working with a sibling to have it deeded to the two of us, and I would like to place that in a trust. Should she purchase or should we sell the property, I can buy her out without her being aware that it's in a trust and guarantee it to expand for further generational wealth. That's what I would like to do. So I kind of got an idea and concept and all these terminology. I'm still learning, but I have an idea. Being a generally intelligent woman, I have an idea of what I want. Does that make any sense?
Yes, it does. So it makes sense in order for if it's like, equal 50-50, it does make sense for you to put it under a trust, and then you guys both can be either, co-trustees, or if you don't want to be the trustee, you guys can be, both beneficiaries in that sense. But can you repeat the part about buying her out? Is that something that you want to do?
If she doesn't want to live in the house and we want to sell the house, but I might not agree with selling it in completion, would I be able to purchase, like, for example, like we're going in separately to sell the house. Let's say someone that was anonymous wanted to buy the house for $500,000 and I was partner with that other person. I could actually buy her portion out. How do you set something like that up as an asset protection and a ghost person to be able to do that and see it through?
So with that instance, I would definitely recommend that you consult with an attorney because it sounds more complicated than I am familiar with, to be
Yeah.
to be very honest with you. But when it comes to both of you guys being, co-trustees, if you wanted to do it outside of like a regular, using a title company and a closing or an attorney or anything like that, then what you can do is you can actually have her like removed from the trust, or you can buy her out and you can actually transfer the asset, or both of you guys do like a quick claim deed and deed it over to a new trust or a new entity if that's what you wanted to do. But that would be like kind of like, like a sibling thing to where, it's not like formally, in a closing proceedings or court proceedings or something like that. But that is how you could transfer the assets if you decided to, create a new trust yourself. You physically, gave your sister the money and then both of you guys deeded the property over to your new entity.
Okay. Okay. And that makes sense. And final question. This was such a high content course or webinar. I would love to be able to listen to it again and just kind of absorb. Will I have that access and ability?
Yes, so I'm actually going to upload this on YouTube. So if you just give me a minute, I will actually put the YouTube channel link, and then you can go ahead and access it there. So it'll be up tomorrow, okay?
Super. Thank you so much. And I really appreciate and value your content integrity and all of the resources that you provide.
Thank you so much. I really appreciate I appreciate the compliment. Thank you, and the good questions. So I'm actually putting it in the chat right now, so you can definitely find the recording tomorrow. Do I have another question? Hey, Mr. Bay, is that you?
Yes, I'm sorry. Thank you. Just my last question in regards to the structure, right? I wrote down the list that you had: LLC, holding company, business trust, private trust, tax exempt trust. But starting out, right, for a person just starting out, what would be the correct structure? Would it be like a 3-tier structure off of that list, or a 4-tier structure, or is that something that I'll find out once the videos on my account is updated?
So you know what, to be honest with you, it's on an individual basis. Everybody is different. And so I'm not sure what kind of business you're operating. Do you want to share that with me?
No, I'm not currently operating in the business.
Okay,
now.
all right. Okay. So you do not have like a LLC or anything?
I have nothing set up.
Okay. Okay. So I would tell you the best thing to do, because not all companies require like a holding company. Not all businesses, like if you're in like a really high liability company to where you are able to be sued overnight, then I would tell you utilize a holding company. But if not, then I would tell you to just use the business trust, set that up first. And then if you wanted to set up an LLC, you would set that up second, so that the business trust is able to own the LLC. It makes sense to do it that way, because if you set up the LLC first, then you are going to be setting it up as you being the individual owner. And then you have to go back and do amendments in order to change the ownership from you as an individual person to the business trust. So does that make sense?
Yes, thank you.
You're so welcome. Thank you so much for asking asking that good question. All right. Do I have any other questions?
I'm sorry, I have one more question.
Yes, ma'am.
The trustee cannot be listed as a beneficiary, like only just as a trustee, like you can't put the same names on a trust, correct?
No, you can actually, the trustee can actually be a beneficiary, but there's like certain, there's certain like rules and regulations. There has to be multiple beneficiaries. I think there has to be a minimum too. It can't just be only you as a trustee and you as a beneficiary.
Hey, Christina, can I add to that? So
Yes, please. Thank you.
individual can't be they can be the trustee and the beneficiary, but it needs to be at least two trustees. So you and someone else is trustees, and then one of those individuals can be a beneficiary as well.
Thank you very much. Thank you. I appreciate that.
Thank you, Antoine.
May I ask another question, please?
Yes.
But I know it's late. I have a situation, I just recently lost my father, and we had a will in place. We have a irrevocable trust in place. The house is currently in my father's name, and my sister and I guess my other two siblings, we're wanting to transfer the house into my sister's name, or it sounds like the best thing that you're recommending would be to probably transfer it into a trust. We recently went down to the Gifford County building, and they gave us these papers and saying that we had to get letters of administration. And I was thinking, well, we have a will, we have the irrevocable trust. Why do we need to do all this? Are we taking the right steps?
Yeah, so there's no way for the ownership to be transferred from a deceased person to a living person or entity without, having that signature, right, from that deceased person. So that's why you have to go through whatever steps your county is telling you to go through. So usually it is like the probate process, but sometimes you don't have to, sometimes you don't have to go directly through the courts, but you do need like legal representation from a lawyer. But yeah, so in order for you to be able to get that ownership transferred, whatever steps they're telling you that you have to go through, that's what you have to do, because you're not going to be able to transfer that property from your father's name to any other name without without the county being involved. Even though you have a will does not protect you from, or it doesn't, like, a will is only, a piece of paper saying, hey, I want this person to have this, but it doesn't actually do it. So someone needs to do it. You need that third party involved, unfortunately.
Even with the irrevocable trust? Did you
So,
get that?
so
I've got this too.
okay, my question is, the house is owned under, is the ownership of the house, the deed is under what?
My father's name.
Yeah, so where does the trust fall into this equation? Did you guys execute the trust after?
No, it was before he passed and he signed it. We got it notarized.
Okay, so did you ever deed the property from your father's name to the trust?
No.
Okay, so then the trust was not used. It wasn't operated. It wasn't put into action.
Okay.
You actually have to transfer the asset from the individual name to the trust entity name.
Okay, so we will have to go to through the county.
Yes.
Okay, thank you.
You're so welcome. Thank you for asking that good question.
Wouldn't that be possible that if the irrevocable trust was listed in her father's name? How you said that you can have the irrevocable trust in whatever name you want to. Maybe it was possible that the irrevocable trust was James Smith Irrevocable Trust or James Smith Trust, which was her father's name.
Yeah, so that would have to have been, already done before like the person passed away. But you're saying like to create an entity with his name?
No, that if she says they already had a irrevocable trust before his death.
Right.
However,
yeah.
if that irrevocable trust was his name. He didn't like put uh just like bill of sales irrevocable trust. He actually named the irrevocable trust after himself.
Correct.
Right, exact. What I'm saying, so you're saying correct. So is that the case?
Yes.
Oh, okay. So, so with that being said, it had to, however, the actual ownership happened or the transfer happened is, is what you have to keep in mind. So the house was already purchased under his name, or it was purchased using his social security. It was purchased legally, through him as an individual, right? So you would have to have transferred it from an individual to an entity, and you have to actually like show that transfer in order for it to be effective. So I'm not sure how that particular, county, how they would actually, see it as, but I personally, if it wasn't transferred from him as an individual to the entity, then I don't see how that's like a viable transfer of ownership, or how the ownership can actually be under the trust. So you would have to go to that particular county to let them know, like, hey, this property is under this entity and not this individual.
Christina, can I add to that as well?
Yes,
So,
go for it.
So, would really be two things that you would need to produce, right? You would need to produce a deed showing that the property was transferred from an individual to the actual trust. And then you would need to show the actual trust agreement, which would be signed and notarized, that would show that asset as being owned by that trust. So you would need the trust agreement, which you say you have the irrevocable trust, which would list that asset as part of that trust. And then you have to provide some quitclaim deed or some deed that has been recorded in the county records showing that one individual deeded that property to the trust as for ownership.
The trustee. Yeah.
Thank you.
Okay. All right. Thank you.
Thank you, guys. Thank you so much. If there's no further questions, thank you so much for joining me tonight. Sorry we went over. It's 10 p.m. now. I know that you guys got to go to bed. So like I said, take action on the information that I provided tonight, and build wealth the right way, using the right tools that you need in order to protect your assets, so you don't have to end up in situations where you doing your family a disservice, because now they have to go through the court system. So if you are interested in working with me, you can definitely email me info@7waystowealth.com, or you can go to thewealthytrustee.com. And this is going to be up on YouTube tomorrow. So thank you so much for joining me tonight, and be blessed, everybody.
Thank you.
All right,
Thank you
thank
very
you.
much.
Thank
Thank
you.
you. Very good information.
Thank
Oh,
you so
yeah.
much.
Night.
Good night.